I'm Harry.
Oh, nice to meet you.
Nice to meet you. Kazinja, I think it is.
Oh my gosh.
And Jim, good to meet you.
Hi, I'm Ash.
Hi, Harry. I'm no longer terrible for you.
I'm so sorry. It's okay.
This might be the loudest one.
It's okay. We're not going to go home.
Oh, sure. Yeah.
So, were you saying that you were going to let us?
So Jackie flew in and she's flying back out. She has her back, but there's one really bad.
So, is Dan not still all there helping her out?
I told her that I would run in and try to find someone from the first side.
Because our, okay. Okay, there. They're all happy. Thank you so much.
We got it. Jackie, Jim,
You made it.
nice to meet you. They let you in.
I know.
I think you're there. We're trying to do in the order that's in the program.
Also just like around to the house and the apartment.
You're reminded about the mics.
No, you just touch it once.
Very good. Well, it is 12:01, so I think we're going to get started. Welcome. My name is Ian Adams. I'm the Vice President of Policy at TechFreedom, which is the event or the organizer of this event today. We are a nonprofit, nonpartisan technology policy think tank, and we tend to work on charting a path forward for policymakers towards a bright future where technology enhances freedom and freedom enhances technology. So we are delighted to have you here today for our event, Will Kids Privacy Crackdown Break the Internet? And so just a couple of housekeeping matters. We are going to go right through the various panels and presentations. So if you have to get up, please just do so. There will not be a break in the middle, but I would urge you to try to avoid the camera shot to the extent possible, and doubly urge you to not trip on wires, because that's no good. And so with that, I suppose the only other thing is our hashtag is COPPA. And if you need to log into the Wi-Fi, the Senate guest Wi-Fi password is constituent at the moment. And so with that, we will turn to our first panel, which is creators in this space. And they have produced some introductory videos, which we will play to start off with. So enjoy. Thank you for coming.
At Sockeye Media, we've got a stand-up and shout audience. Our team of educators is devoted to creating original content that will delight and inspire children. We make preschool videos that are thoughtful, educational, and entertain kids worldwide via our Mother Goose Club family of channels on YouTube. Kids love them because they're fun. Parents love them because they encourage learning and family bonding. How do we know? Well, on any given day, families watch our videos millions of times. Altogether, that comes out to billions of views and millions of subscribers. Plus, our fans show us through videos, pictures, and emails, and by commenting on our videos. So, who are our fans? Our audience is young children and their parents, grandparents, and caregivers, and they rely on Mother Goose Club. Our broadcast quality videos are short, 100% safe, and full of color and fun. That's why kids tune in from around the world. They know that Mother Goose Club means music, dancing, and learning. Mother Goose Club is a true interactive experience. Kids don't just watch, they sing, dance, clap, and giggle along. And parents follow right behind, recording and sharing the learning moments. Parents like what they see, so they come back again and again. As one of YouTube's leading family channels, we're a trustworthy choice for any device and any situation, from birthday parties to road trips to cozy afternoons at home. So join Mother Goose Club, where learning is fun, where kids love to play, where families come together. Mother Goose Club, preschool to the world.
Hello, Washington.
as a Canadian, I wanted to say thank you for not having below freezing levels of weather, because it's pretty cold up here in Canada. With that said, my name is Jackie from the YouTube channel Nerdy Crafter. Here on my channel, we focus on celebrating geek culture, so even though
content. And so that was a lot for us to be sifting through, and we decided to shut down production of J House Jr. because of all the unknowns, uncertainty, and the loss of revenue. And YouTube came out and said that this will have a significant business impact on those who are making child-directed content. But like Harry said, the implementation of that just happened within this week. And so it's too early to say, here's exactly what happened. But what we plan to do is to compare, analysis of what happened a year ago and do that month by month to see what the differences are. But it's too early to say for sure what that looks like.
I myself, I have a few friends that were also YouTubers, and they've been directly affected by this. And a few of them have reached out to me and reported that they've lost revenue up from like 60% to 90% of their total ad revenue, which, obviously that's not viable. Some of them are having to completely shift their content to be more mature, more edgy, more adult focused, so it doesn't qualify under this COPPA bill. And a lot of them are completely having to just quit YouTube and their channels altogether.
I don't think mine's working. Oh, there it goes. Ooh. So for my channel, usually when I do crafting, I like to think that my channel is very inclusive. But with all the changes that have been happening, I find myself intentionally, slowly starting to use kind of alienating type language. So instead of saying you can do this with your kids, I could say you can do this with beginners. So I'm starting to shift my language, even though this is supposed to be, crafting is a medium that we can all use in order to de-stress and have fun. But when it comes to all these rules, I find that I am starting to shift my language and how I want people to see my channel as not something that's just child-directed. In addition to that, because these changes haven't been fully, we haven't seen the full wrath of it yet, a lot of people in the crafting community who are using watercolors and colored pencils have actually been flagged and had their comment section turned off. And these are channels that make content for people who are above the age of 18 or teenagers and up. But at this point, they also did get hit and their comment sections were turned off and they started panicking as well.
So you guys have mentioned actually two things that are already happening. It's the comment section and the targeted ads that are being taken away. What else from the changes in how YouTube operates in this space has affected you? So comment sections, playlists, notifications, any other kind of structure or infrastructure or opportunities that were taken away?
Yeah. On a video that's designated as made for kids, not only do you use the personalized ads, and the comments are really a big deal. I mean, you think about this as a creator, what sets us apart from TV is we're able to actually interact with the audience. And for us, with family content, we regularly have people asking about the recipes, or they're asking questions, or they're giving advice. Like one of our sons just had seizures and was diagnosed with epilepsy, and we have people wanting to reach out to us and tell us about their story or their experience and creating a community around these different topics. So comments getting shut off is such a loss. We've spent hundreds of hours responding and building those comments, and then they're just gone. The other thing that's really a big deal is on videos, there's a feature called iCards, and you're allowed to put 5 of them on each video. We do a poll on every single video, again, that interactivity where we're asking a question. Do you know someone who has epilepsy in your family or extended family or whatever? And we're also able to recommend videos that are related to what we're currently going through. You know, we recently just had some serious earthquakes in our family, and we made a video about that. And right when we're talking about it, I can put an iCard that says, you know, here's another video we have where we had an earthquake, or another one where we went through a tornado as a family. Those features are being removed along with end cards. And so a lot of features that allow us to connect and engage and have good experiences with our audience are being removed on videos that are child-directed.
I would say think of the comment section, because I'm going to talk from experience. I'm also a college professor in addition to doing YouTube. So think of the comment section as a classroom. And you tell your students, you can't ask questions and you can't have anything in terms of an enrichment other than just watch me lecture in the front of the classroom. The classroom just, it won't evolve. You won't have a sense of community. You won't have a sense of engagement. The students won't learn. You're removing everything that makes a classroom engaging in terms of the Socratic method, for those of you who believe in it. That's what the comment section is for most of us here on YouTube, is that we are engaging, we are enriching, and it's a learning experience not just on one side, but both sides as well. There are many times where I've used the material and people are like, well, you're doing it wrong, and then they give me the right way to do it, and so I am also being enriched by this experience as well.
I also want to say on the topic of live streams, if a live stream gets marked as for kids, then it completely shuts off the live chat as well, which pretty much completely defeats the purpose of a live stream because they can't live interact with you. There's no way to donate. That gets removed too. So at that point, you're basically just, like talking to a wall.
For our audience, I would say the major loss was playlists. For the parents of young children, I would say that perhaps the most important tool that they use to curate and manage their child's experience on YouTube was by having their own private playlists. For them to lose the ability to create playlists with their family, I would say has affected quite a lot of families. I would say on the playlist front, we do have our own playlist that we put out there, and users do use our playlist. I would say we used to have a situation where we would take our playlist and then change around the videos after a while, especially if we had new videos. We would promote our latest video. And what we got feedback from a number of families was that in many families, they want to watch the videos a particular way, especially if the children are special needs and the change in the programming affected them. So we just create a new playlist then, and we basically just leave our playlist the way that they are. And I know that many families had their own playlists. A lot of parents were relying on it, and it's a blow for them to lose that feature.
So with Mother Goose Club, I think it's a little more clear on who its kind of the main audience is. But with the rest of our creators, do you guys mind actually elaborating, again, for people who are not familiar as much with your work and just saw the intro clip of, like, do you have a sense of percentage of who watches your videos? What age groups are they in?
So on that topic, it gets very hard, which is actually one of my primary concerns. So, like, one of the games I play is Minecraft, and while Minecraft was probably originally intended for teenagers, it's not one of the biggest games in the world, and it has seniors playing, it has kids playing, little kids playing, teenagers, adults. And the thing about the internet is everyone is completely anonymous. I can make an account and say I'm a 55-year-old dude who watches, My Little Pony. It's not true, but I could. And so as a result, you really don't know who is watching your videos. And in terms of me, only 5% of my audience ever comments or interacts. So the other 95%, I have no idea who it is watching my videos. There's no way for me to tell.
So YouTube does provide us analytics, but it's for ages 13 and up. And we do use that. I mean, we've done brand deals on our channel with T-Mobile, Bed Bath & Beyond, Google, Amazon, a lot of different companies, and we'll send them those analytics and say, look, here's the demographic by age and the demographic by gender and location. All of that is aggregated together and given to us, and we can send that and use it. But as it relates to COPPA, we're being told that's not reliable information as we determine whether our content is made for kids or not. And so we're left in a lot of ways guessing what is and what is not, like Creekcraft was saying.
I know that I predominantly make content for a very specific audience, which is geeky female crafters. And to say that I have about 85% of my audience are female above the age of 18. So I do have that information, but again, these are analytics that we are given only as of the age of 13 and up. So the majority of my audience is in fact, according to the analytics, between the ages of 18 to about 45.
Just wanted to note that it's one thing that we've learned from this process and this conversation is that there's there's very little information out there about how little information we have about our audience. There is quite a lot of privacy on YouTube and on the internet, quite frankly. We just don't know. There's the information that we will get about our audience is very much aggregate information outside the U.S. on the country level. In the U.S., it's aggregated to the state level. We have information on logged in users, but again, it's only 13 and plus. So, for example, with our audience, we know that most of our audience is under the age of 5. Of course, the actual demographics will show basically primarily people in their 30s and 40s, and then people over the age of 60, right? So we're looking at probably the parents and the grandparents. For us, that is actually in many ways the key audience because they're the ones who are selecting our program, right? So the young children who watch our program are not the ones who are in control of the device. They're not the ones who are actually necessarily deciding to watch our program. We need the parents and the caregivers to be fans and to understand what we're trying to do and to want to put us in front of their kids. And so in many ways, like when we talk to our fans, of course, they're the ones that we're actually talking to. They're the ones who are reaching out to us. And they're the ones that we're engaging with. And so that's a very different dynamic than each of the other creators on this panel. And just goes to show how wide and diverse the range of different audience segments are on YouTube.
Yeah, my wife and I regularly use Mother Goose Club in our home. And one thing I just want to point out too is this is such a small group of YouTubers when you consider all the different genres. We have gaming, family vlogs, crafting, and preschool education. But you consider all the content that may be attractive to children and that are going to fall under questionable areas here. You think of the music. Like, go to YouTube Kids right now. How many music videos can you find there? A lot. You think of sports. Like, I like watching the NFL highlights with my kids. That's on YouTube Kids. You think of all the different things related to toys and, education that isn't for preschool, like all those science videos and creative things like that. Comedy, food, beauty, animation, like all of these categories are up on YouTube, and the creators are confused and not sure what to do. And YouTubers are creative. We're combining and collaborating all this content in a bunch of new and different and diverse ways too. And so all of these questions come up of who is watching, what is the audience, and we know that it's likely that children 12 years old, and then again with the Protect Kids Act, if you raise that to 15 years old, like sure, 15-year-olds and 12-year-olds like watching all these different types of content.
You guys also nailed it on the head when you said, you mentioned My Little Pony. There's a huge amount of adults who watch it. There's a lot of nostalgia about it. I personally have looked up, I remember from my childhood, Sailor Moon videos. They're also on YouTube. And I was like, oh my God, remember when I was 6 and this was it for me? So there's such a hard line that you have to walk when you create any content, because it obviously there are a lot of adults who would be interested in too, and sometimes there are children who would be interested in too. You mentioned beauty. There's a huge following amongst preteens and teenagers for beauty YouTubers, and their content sometimes, if I'm watching it, I would be like, I don't want my little sister to hear these words yet. So it's very tricky. And I think we should go to the next question and ask the question of, well, what do you do? Do you collect the private information? Do you collect personal information? Because COPPA was supposed to protect children's privacy, protect their personal information, and that was the whole goal. And I think it's kind of, obviously, you as creators, your goal is to engage children, engage imagination and their development. But at the same time, there still are out there people who paint you as the bad guys. I don't know how. If they saw you, they would think that, but they do. And so do you guys collect personal information? What do you do with it, if you do?
I mean, we have to think about what kind of information we get from YouTube. We practically just get pie charts. That's it. We're getting just big charts that have divisions, and that's the deepest kind of data that we have, which is age, where geographically our audience could be from. That's about it. We don't have any deep dive information or personal information about anyone at all.
I would say that on that front, this actually goes to one of the things that also was surprising about the settlement, which was when we creators were being identified as operators. That was a surprise because we don't control YouTube. We don't really have any capacity, quite honestly, to do very much about the platform at all. I mean, they provide it to us. They tell us what we can see and what we can't see. Having said that, what do we see? We see information at a country level. In the States, it'll be at the state level. But again, it's how the information is obtained and what it relates back to doesn't get shared with us. And quite honestly, I would say that for, if you think about the logistics, it's quite impossible for us to really do much more with information beyond that. I don't think anyone, I'm not aware of anyone, I've never been interested in information that was more granular than that. If you're talking about hundreds of thousands of views, and some of us have tens of millions of views a day, it's just not practical to really look at anything more than general trends at a very kind of zoomed out level. I mean, you're looking at what the audience is, how the audience is behaving, maybe in terms of, when did they click off, the stuff that they don't really share with you in detail of when they stopped watching your video. You'll find out generally when people will click off your video. But other than that, as we all noted, we have quite a lot of communication with our fans because they reach out to us. There's really no way for us to reach out to them. We don't have the ability. We have subscribers on YouTube. We have no ability to message them. The only way that we can message them is by posting a video. So they message us, and then we respond to them. I mean, certainly when we had comments, we could respond in the comments. But again, we don't know who they are in the comments, and we don't have access to their Gmail. We can't send them emails. And I would say nearly every creator responds to almost every comment. And we get millions of views a day. We respond to everyone. I mean, not right away, but eventually. And that's a big part of the experience, and that's why people engage with YouTube so much. They know that they can reach out to, Nerdy Crafter for crafting advice. They can reach out to us for parenting and preschool education advice, and we'll actually engage and respond to people.
If I'm not mistaken, doesn't Mother Goose have billions of views?
Yes.
Total? If you had all that information, that would be amazing. Now, let me be clear. If that would be some fascinating research, but you don't. And I guess my question is, so now you guys are implementing these changes. You also led a petition on change.org, which I believe has almost 1 million signatures now, that's asking the Federal Trade Commission to look again into this issue. And because all the creators are being hurt and the content is being hurt, and hence the children and their experience is also being hurt by these rules. Would you say, what feedback, if any, and reaction have you gotten from your subscribers, support? What were their comments and their thoughts on this change that is happening?
I think one of the big things, the primary purpose of COPPA was to put parents in control of protecting children's personal information online. And when you look at the reality of what's happening right now in 2020, there was a Pew Research poll that showed that 81% of parents were allowing their young children to watch YouTube. So the reality is parents are taking devices that they've purchased and then handing it to their kids to watch YouTube. And what this regulation does in some ways is kind of bypass parents by saying we're going to now be putting liability on the creators, those who maybe don't have control over notification, they don't have control over the requirements of complying with COPPA. But one of the concerns I know from creators, I've heard from other creators, is that where is the responsibility on parents? And also, are we ignoring parents' preferences? I mean, in reality, a lot of what the FTC settlement is doing is trying to protect children from their parents' choice to allow them to watch YouTube, which that was never the intent of COPPA, is to protect children from their parents, which is what's actually happening. So let's make sure that we're putting responsibility where it should be, and then we shouldn't be passing on liability to those who lack control, like the creators.
Another thing I want to say is that my generation, especially the younger ones, we primarily watch YouTube. People come home from school, kids come home from school, they don't watch TV anymore, they watch YouTube. And so what's going to inevitably happen here is if kid content is no longer monetarily viable, then people aren't going to make kid content. But the kids aren't going to go away from YouTube. They're going to stay on YouTube. So now you have an entire generation of kids just hearing people swear and watching more mature adult content because that's the only kind of content that can be monetarily viable.
One of the things I would really like to see is a more defined, well, I guess less vague definition of what kid appealing or child appealing content is. Because when you look at the list, things like pets, I have my parrot who's in my videos sometimes, but again, I don't have, it's not child directed, nor am I targeting children, but at the same time, these definitions of pets or colors or music, these things make entertainment. They don't necessarily make child content only. So if you have a video with no music, it's not necessarily going to be, in terms of editing, at least more appealing. So these are things that I would like to see in terms of something a little more defined, less vague, and also removing the fact that adults are adults. So YouTube also started to treat adult viewers as coming from children when they're watching content that they deem could be child-directed. And that's pretty condescending when you think about it, as an adult who's being treated as a child. So that's something else that I would like to see revised as well.
I would say that, again, the impact has only really been implemented for the audience this month. So we're still hearing from people. I would say the one thing that somewhat surprisingly, and to some degree, that we had been hearing from people, even like my friends, was, does this affect you? And I think that was, and they would, obviously we make child-directed content, but I think everyone kind of assumed that, well, they have their own experience with YouTube and that this wouldn't affect their experience with YouTube. It would affect someone else's experience with YouTube, especially if you were not based in the US. And so for a lot of the conversations that we've had, it's been actually, it's going to affect us and everyone else. And yes, it will affect you too. And there's nothing that you can really do about it, as a parent or as a user, as an adult user. And that's been a surprise to nearly everyone, and something that, like, even this past weekend, I was getting messages from people I knew saying, does this affect you? And like, how do I stop this? Like, how do I stop this for myself, right? How do I get my experience back? But, I don't control the platform. So there's nothing I could really do about that.
And again, one of the things that I had mentioned in my video is that primarily in the crafting community, the gaming community has a lot of also issues that kind of overlap, but at the same time, in the crafting community specifically, we are hurting female entrepreneurs because we're putting female type hobbies as child hobbies, which again is definitely not the way to go about it. If we like to customize dolls, a lot of the materials that we do use are not for children either. We're using epoxy resin, and we're using different kinds of sculpts and sharp blades and Dremels, but we're not using power tools per se in the same way that our male counterparts are using in the crafting community. So I'm really, really worried about the definition of what a child appealing type hobby in terms of what female type hobby is, and putting them all in the same basket, because this idea is really, really going to hurt female creators and entrepreneurs. And a lot of them could be also stay-at-home moms who have figured out a way to use their talents to make a living.
Yeah, the other thing too, we talk about how vague the standards are. There's these 3 different categories that your content can be: child-directed, mixed audience, or general audience content. And we have these 10 factors that the FTC have given in the COPPA rule that we are supposed to consider whether or not the content is in which category. And how COPPA applies to us, whether it does or not, depends on which category it's in. And you look at the 10 factors, we don't know as creators what they mean. Like, one of the factors is language, and there was a document from the FTC back in 2002 that says, is the language simple enough that a 12-year-old can understand? And it's like, well, what YouTube content isn't, Are there characters from movies that are talked about? Or, all of these definitions that they're giving, the subject matter, the visual content, the age, the fact that there are children in my video, does that mean it's child-directed? Well, obviously, there's a lot of general audience content out there that has children in it. And so one of the things we're needing is a lot more clarity. For me, it's been concerning that it's even questionable, and there's this issue of even the constitutionality of it. I mean, we should know whether a regulation applies to us or not. When there's a speed limit sign, you know whether you're speeding or not because there's a number. And with the FTC, it's almost like we're given a speed limit sign that just says, don't go too fast. And we don't know whether we're going too fast or not. And then we ask for examples from the FTC, and they're saying, well, if you're going 5 miles per hour, that's slow, that's okay. But if you're going 125 miles an hour, that's too fast. Like you talked about in a conversation you had with FTC where they said, you know, Dora the Explorer is for kids and Grey's Anatomy is for adults. And it's like, we know the extreme examples, but what about the Cosby Show? You know, and what's concerning is that in the complaint, they highlighted a family vlog that has over 2,600 videos. That's about a teenage daughter and a daughter who's younger than 13 and 2 parents. And they said the whole channel is child-directed. And they highlighted one of the videos where the teenage daughter dyed her hair purple. And they said, but look, YouTube has designated this as for kids, and YouTube put it on YouTube Kids, and YouTube had emails with their employees that said this and that. And it's like, well, what did the creators do? Well, the creators in their About section said that they were family-friendly. And that's not okay, you know, and they have these videos about dyeing their hair purple. And so we just come begging that as you consider changes to COPPA, it has to be more clear because we don't know where to designate ourselves. And there's so much in the middle. What about those going 20, 30, 40, 50, 60 miles per hour? We're all left guessing, and we feel like we're going to be judged or could face these penalties and could face losing our businesses. And the other thing, too, is just the magnitude of it. Like I said, I have 1,400 videos, so I have to consider those 10 factors in the totality of the circumstances with every one of the videos, and then say, where should I line it up? And I've talked to probably 10 attorneys about this, and they all interpret it differently. And so where do I draw the line? And I really don't know, and I'm trying really hard, and I'm an attorney as well.
I think that's fascinating to have a creators panel of an attorney because you're doing my job for me. It's awesome. To wrap it up, this room is full of staffers and privacy experts and advocates. We're also on C-SPAN, which is Peak Nerd DC. So if you want to address all of those people, we have FTC Commissioner coming in later, and ask them and plead your case, now is the time. Let's go down the line. I know it's a lot, but like, what would be your ask? What would you want them to look into and to hear you out?
Well, that's heavy. Like,
I'll start. Changing the age from 13 to 16 just makes things more confusing because you're measuring the nature of the content rather than the users. And that creates all kinds of enforceability problems and potential, there's so much confusion. You can start to feel discriminated against because you're getting called out on, but then the guys who are doing trick shots aren't getting called out on, you know? So why are we looking at the nature of the content as the measure to determine and raising the age? So here's the thing. Yes, we all know the difference between content made for a 3-year-old and content made for a 33-year-old. Who in here could tell the difference of content made for a 12-year-old and for a 13-year-old? It's indecipherable. And then how could you tell the difference between content for a 15-year-old and a 16-year-old? So that change, yes, it will bring in more general audience content, but it just confuses the issue. The other thing, too, is the FTC in their 2013 changes said that they wouldn't put more emphasis on one factor above another, but they're beginning to do that. They're starting to put emphasis on the factors that YouTubers don't have control over. So as you put emphasis on the audience itself, we don't have control over how YouTube is suggesting us on YouTube Kids and how many of the kids there are seeing it based on their recommendations. So I can have a video that I posted back in 2014 that is, you know, general audience content. But then in 2019, YouTube could suddenly start promoting it on YouTube Kids, and it can get 1 million views over on YouTube Kids. And so that means I have to be monitoring that content every year, checking to see what YouTube is doing with it and who they're recommending it to see if the balance has shifted to where now the FTC may consider that content made for kids. So as you put the liability on people who lack the control, that's bad policy. So as you're thinking about changes for COPPA, don't put the liability on the people who don't have control. The people who have control are the parents who have the best control over the responsibility for their kids, but the creators who can't get notification and consent shouldn't be the ones who are getting the liability here.
Something I want to say too is the internet is not black and white anymore. So like SpongeBob, for example, I grew up watching SpongeBob. Just because I turned 18 and I, became an adult, I didn't immediately like, oh, I can't watch SpongeBob anymore, right? So if I see a SpongeBob video on YouTube, I'll still watch it. And so I'm sure there's a lot of content on YouTube that may be deemed or looked at as for kids, but I'm sure it has a big adult audience. So number one would be to keep stuff like that in mind. And then number two is when making laws like this, please consult with people that do use the internet, and don't make laws for stuff you don't understand.
Also, one of the things that I think is really important is giving adults the choice to decide what their kids and what they want their kids to do. So consent is really important, and I don't think that that should be removed from parents or people who are giving their tablets to their kids, basically. So that's one of the important things. And the other thing is definitely, a lot of collectors, whether it be video games or figurines, these are people with purchasing power. So saying that, again, SpongeBob or Ninja Turtles is just for children is kind of detached from the reality that we live in, especially since a lot of the conventions like Comic-Con are extremely popular. And again, the majority of the age is between the ages of 25 and 34.
I would just like to echo the point about making sure parents are empowered. Parents should have the right to decide what kind of internet experience they want to have for their families and for themselves. I'd also like to stress the need to really identify the harm that we're trying to solve. I mean, there are a lot of problems on the internet that we would all agree should be addressed. What's been described about, certainly, for example, whether or not we collect information and how we target kids, no, we don't. And most of what's been alleged about the creator involvement is just not technically true. There are things out there that do need to be addressed. We would love to partner with you and share our insights on how the internet works with you to do all of that. Let's make sure that we're addressing the right things and not compromising, what we have, which is, to be clear, for the first time in history, we have the ability for anyone in the world to have access to an unlimited amount of video content. Some of it's not great, but most of it's awesome. And it has benefited and enriched billions, most of whom would never be able to afford a subscription video service or have access to videos like the videos that we make and the videos that the hundreds of thousands of other creators worldwide make. We should appreciate that, and we should celebrate that, and we should make sure that content gets better, not worse.
Thank you so much for making the case, for listening to creators, and for sharing your experience. If anyone in the audience wants to get in touch with you and you just express that you're happy to collaborate, you guys can come to us. We'll put you in touch with our amazing creators. Please join me in thanking them for coming all the way here to DC and sharing this with us. And the next panel is going to start without any intermission, so please stay in your seats.
So go TechFreedom. You may mistake me for Harry because we're wearing the same outfit, which was not planned. Thanks again for coming. I think this is the fourth COPPA event that we've done over the years. And Phyllis, I think you've done all of them. So thank you, including back in the days when you were at the FTC. So we just jumped into the middle of things with our content creator panel. So you've heard from them what their frustrations are and the practical concerns that they have. In this panel, we're going to talk about why they're in that situation. You heard a lot of terms tossed around in the last discussion: directed to kids, collection of information. We're going to unpack those now. We thought it would be better to just start with you hearing from people in the real world. I want to introduce our expert panel today. As I said, we've had a number of these folks on panels in the past. Angela Campbell is a professor at Georgetown Law. Her clinic represents the Campaign for a Commercial-Free Childhood and the Center for Digital Democracy. They've been among the groups that have been leading the charge for the FTC to do more about children's privacy, and they filed the complaint that ultimately led to the settlement that we were hearing about on the last panel. So Angela is going to explain the concerns that led her and her group to do that. Jim Dunson is my colleague at TechFreedom, our general counsel, and somebody who has for the last 35 years done a lot of work on COPPA, representing content creators online, also representing the largest creators of children's media for television. So thanks to Jim for coming. Sarah Holland is a public policy manager at Google. She advises teams on privacy and data governance and has been working on children's privacy for over a decade. Phyllis Marcus, I got to know initially when I started working on COPPA back in 2008, and you were Mrs. COPPA at the time at the FTC, and you worked on the 2013 rulemaking and were there through 2015 and have been out there representing clients in private practice trying to deal with COPPA since then. And Amelia, the latest addition to our panel, I didn't get a bio from you, so lest I misstate anything, why don't you introduce yourself to the audience?
Perfect. Turn on. Yeah, there we go. I am Director of Youth and Education Privacy for the Future of Privacy Forum.
And you focus on COPPA and? Focus
on COPPA, YouTube, and the 130 plus student privacy laws that have passed since 2013.
Okay, we'll talk a little bit about the intersection of those two things. To get started here, so we keep talking about this term COPPA. It's the Children's Online Privacy Protection Act. This is actually the third attempt by Congress to regulate the internet to protect children. The first two laws, the Communications Decency Act of 1996, and then COPPA, very confusing, the Child Online Protection Act, also 1998. Those were both struck down in court as unconstitutional. So COPPA was Congress's first attempt that survived. And it survived and has avoided constitutional challenge thus far because it has been focused on trying to regulate not the entire internet, not affecting adults and content that's enjoyed by adults, but rather the collection of information from children, which could include things like kids putting in their names and their home addresses in free text fields online, as well as some other information we'll talk about, in two situations. One, where the creator has actual knowledge that they're collecting information from a child, and as we've heard, on the internet, nobody knows you're a dog, so that doesn't always apply. But then second, a situation where the content is directed to children. And that's what we're really talking about on the last panel. So just to get us started here, I want to ask Jim just to tell us what COPPA was intended to do, and then Phyllis to jump in and update us on your thoughts on that and what the FTC was trying to do when it updated the COPPA rules in 2013. So Jim, what do you think the FTC was doing?
I think they were trying to turn their mic on.
Any luck?
Any better? Yeah, there. So really, if you go back and you look at the legislative history of COPPA, there were two areas generally that COPPA was designed to do. First and foremost, it was designed to give parents control over the information of their children. So it really was a parental control. But really, the protections were twofold. One, and really almost primarily, was from predation. In the 1990s, there was a great fear that child predators would camp out on the internet. They would reach out, they would find children and do horrible things against them. And in fact, if you look at some of the testimony in the Senate hearing on COPPA, then FTC Chairman Robert Petoskey talked in great detail about the FBI and the FTC working together to try to make sure that the internet would be safe from predation. Secondly, was a form of over-commercialization that the congressmen were concerned about, and it was specifically about the ability of advertisers to pick out individual children, find them, and market directly to them as individuals. And so that was the sort of the benchmark on COPPA. And as we go forward, we need to understand that in the statute, the definition of personally identifiable information, PII, was fairly limited. It was limited to the things that you would traditionally think are really personal information: a person's name, address, serial number, email address, things that could be used to contact directly an individual child. That has been expanded, and we're going to talk about specifically what happened in 2013, increasing to things like geolocation information and this really pesky thing called persistent identifiers, aka cookies, which is where really the crux of the debate is around today. But that's sort of where we came from.
And just for context here, the chairman of the FTC at the time talked about the dangers posed by predation and pedophiles online, and said, although there's little evidence directly linking commercial data collection to these problems, the practice of collecting personal information from children without parental consent is clearly troubling, since it teaches children to reveal their personal information to strangers and circumvents parental controls over their family's information. So that's the link back in 1998. And there's been a debate, because it's unclear and it's always difficult to rely on legislative history. There's been a debate since then about exactly what that meant and what Congress intended for the FTC to do with that. And as Jim notes, the FTC was given some wiggle room, because the one term that the FTC was able to use to expand the scope of COPPA was the meaning of personal information. So initially it was, name, address, that sort of thing. And then also any additional criteria that the FTC determines allows the contacting of a specific individual. So that change happened back in 2013. I want to ask Angela to provide her perspective, but first, Phyllis, can you just update us on what happened in 2013 when you were at the FTC? And then we'll talk about the debate today and the conflicting views as to what that discretion should mean.
Sure. So as Barron set it up nicely, and Jim as well, everything in the FTC's ability to regulate children's online privacy came directly from a statute that was enacted in 1998. The FTC promulgated regulations that went into effect in 2000, and there were some mandated reviews that had to occur under the statute, and then periodically the FTC reviews its rules to make sure that they are current. And so there was a wholesale review that took place from 2010 to 2012, and the revised rule went into effect in the middle of 2013. There were a couple of major changes that took place in the 2013 rule review, one of which was this expansion of the definition of personal information. And the constraint was that the statute indicated that the FTC could only expand the definition where the FTC had made a determination that a different identifier, or a newly added identifier, permitted the direct interaction between an operator and a child, that is, permitted the operator to engage with the child. And so there was a full-scale analysis opposed by some in the industry, strongly supported by others, and ultimately the FTC determined that there was sufficient evidence that a cookie, a persistent identifier that could be used over time and across a body of properties, so however defined. Mobile apps were relatively new at the time. We've kind of moved beyond mobile applications to lots of other types of internet-connected devices, but over time and across a body of properties to communicate, however you would define communication, one-on-one with a user. What that meant, kind of boiling it all down, was that behaviorally targeted advertising that permits an operator to track a user over time and then tailor particular marketing communications back to that user would now be considered to be personal information as defined under COPPA.
Okay, so there we were until last year. And critically, in that 2013 update, the FTC had said that this amendment would not apply to uploading photos or videos on general audience sites such as Facebook or YouTube, absent actual knowledge that the person uploading such files is a child. In other words, this is there's two critical distinctions in COPPA. There's those two prongs that we mentioned earlier, the actual knowledge or directed to standard, and then there's the question of, is this a general audience site or is this something that's geared towards individual users and, to children? And until the YouTube settlement last year, the FTC had said that YouTube specifically was like other general audience sites where most people that were using the site were adults or older teens. And so the only way that COPPA was going to be triggered was if someone had actual knowledge they were collecting information from a child. So what changed last year? There was a complaint filed in 2016, I think? 2017, Angela? And I'll let Angela jump in and explain this, but that has led us today so the fundamental shift has been, step one was the 2013 change, step two was the COPPA settlement, which for the first time has essentially done away with what the FTC said in that footnote, and has said that YouTube is no longer going to be a general audience site overall, but then they're going to look at specific channels and specific videos on the site to assess whether those are child-directed. That's why we're here today. That's why the last panel is now talking about being held liable under COPPA because of those two changes intersecting. So this is what we want to talk about primarily today. Remember, if you have questions for the audience, we're a little tight on time, so we're not going to have a question session, but feel free to tweet at us on the COPPA hashtag. I'll keep an eye on those questions and try to work them into the discussion. Angela, what prompted you and your groups to file the complaint that you did?
Okay, so when YouTube Kids was first announced, we conducted an investigation of YouTube Kids, and we actually ended up filing multiple complaints with the Federal Trade Commission about it, which they did nothing about. YouTube Kids did not violate COPPA because it didn't have behavioral advertising. It had some advertising, and it was what we would call contextual advertising. So
there's no cookie that's tracking the user from video to video.
Well, there may be, but it's not used for sending personal advertising. It is, I think, used for recommending videos.
Right. In internal operations of the site, but it doesn't fall under the rule.
So, but what we realized was that all of that kids programming on YouTube Kids was coming from YouTube. And my clients kept asking me, they said, well, how can YouTube get away with this? Because they know they have children's content, and yet they're pretending it's not a children's content. And so after much investigation, it was actually in 2018 we filed the complaint. I just checked, April 2018. We filed a complaint against YouTube. Now, let me clarify. We did not file a complaint against any creators at all. This was only against YouTube. And we had several different theories on which we alleged that YouTube was violating COPPA. One was the actual knowledge standard, and part of our evidence of actual knowledge was that they knew that they had these channels on YouTube that they were also putting on YouTube Kids, so they knew they were intended for young children. We had other evidence as well. But we also argued there were two other grounds, and that YouTube was in fact directed to children, that the largest audience for YouTube is children. That's where children are. And that also that YouTube, as a YouTube's parent Google, as the main advertising network, knew there were kids, and they knew they were advertising using behavioral advertising to kids. They were actually doing the advertising to kids that they knew were kids. So we had several different grounds on which we thought YouTube was liable under COPPA. And when the FTC ruled, it was actually, we were kind of surprised that they based it on this very narrow ground of saying, well, they had actual knowledge, and therefore, to settle this thing, you have to have the creators then tell you whether they're child-directed or not, and then if they're child-directed, then you can't do behavioral advertising. So that wasn't really the result we expected or wanted, and I have a lot of sympathy for a lot of the creators. And I do think that YouTube should be taking a lot more of the responsibility of complying with the law. And part of the reason we did it was just a practical reason. We couldn't possibly, I think that as a matter of law, all the creators are responsible, but I also think that there's a lot of misinformation. In other words, I think a lot of the things that people are, I understand why you're worried, because I agree that what is child directed with 10 different factors and trying to figure out what the FTC might, there's no case law on it. The FTC has never, brought no cases that they've actually litigated. So I have a lot of sympathy, and I think there needs to be improvements in what's the current situation, but I do think it's really important to protect children's privacy.
Okay, so keeping in mind that we have a lot of people in the live audience, the C-SPAN audience, who will not be familiar with COPPA, Phyllis, could you summarize what exactly did the FTC settlement with YouTube do? Just what is?
I think I'm probably not the best person to speak.
Sarah?
Let's have Sarah do it.
Oh, no, I was actually thinking Phyllis would be the best person to do it. Because I think one thing is, there's been a lot of focus on YouTube, but COPPA, and I think that's one of the reasons Amelia here has a broad impact, right? YouTube is very much a big name in the conversation, but is by far not the only. And I know Phyllis represents a lot of different clients that have been impacted by this as well, and perhaps it's more helpful for someone outside of the settlement to talk about it as opposed to someone who was in the settlement. We can obviously point people to a lot of information on the record as well.
Okay, well, we're short on time here. I just need someone to give us a really quick overview of what the settlement requires. So, someone.
You want to jump in? Okay, I'll take a whack at it. And, we have a commissioner in the audience, so he can also speak to it as well. My understanding is that, as with every children's privacy settlement that the FTC has entered into, the entities involved, Google and YouTube, have to comply with COPPA going forward. They have agreed within the settlement to pay a large sum of money, and also to implement a system and maintain it whereby individual operators can flag for YouTube that they are directed to children. And then YouTube has decided, from what I'm understanding, that it will implement the rules by turning off particular features or altering particular experiences. There are choices to be made, but the baseline requirement is to comply with COPPA. And so the choice has been to alter experiences, as we've heard in the room, and YouTube is offering a number of resources for the operators to understand whether they do or they don't fall into particular categories.
And the features that are being turned off here are those that implicate collection, right? So we've been talking about.
I think that's important to draw the distinction. The FTC, the consent decree says you have to have a system that will accomplish this end, but they don't say you can't have comments, you can't have playlists, you can't have, all these things that YouTube has decided you can't have. Maybe the way YouTube has them set up right now, they can't let you do them because it would allow children, say, to comment, but there's no reason in most cases that they couldn't have comments and have playlists and these other things without, without collecting personal information or without allowing children to comment.
Okay.
I think this is all a really good point, though, because you have to talk about what is in the settlement, which is follow COPPA, what Google is required to do in the settlement, which is actively seek out knowledge that something is directed to children and then train basically the content creators on YouTube. And then there is how it actually is in practice, which has been sort of turning off the comments, playlists, that sort of thing. And additional steps that YouTube has taken, such as using AI, which was explicitly ruled out by commissioners as not part of the settlement. So there's sort of these
using
three
AI to
different
determine
buckets.
what is directed to children.
Exactly.
Okay, but I just want to make sure the audience is following that the features we're talking about here, the reason that they're implicated is because they involve a collection of information. I think when people hear that term, they're often thinking like they'll naturally think about the cookie that enables the ad that shows you that's relevant to you, not just based on the content you're seeing, but on other things you've looked at. But we're talking about a wide array of features here, and it's things like comments, because you can put in free text. That's considered collection. That's not intuitive to people outside COPPA land.
And actually, it's quite intuitive because you don't want kids saying, "Hi, my name is so-and-so, and
Right.
I'm 10 years old, and you can reach me at or I live at."
Well, so yeah, I agree, and no one would dispute that that's what Congress was intending to cover in writing COPPA in the first place. But I just want to make sure we're making a connection between this panel and the last panel, where the content creators were explaining that they are seeing features disabled like playlists, right? So a wide array of features that reduce their ability to build an audience, especially as small content creators who are trying to attract attention. Okay, so that's the realm of what we're talking about. Now the question is, why are those features being disabled? Why isn't there a way, a practical way, to enable them with the verifiable parental consent that COPPA requires? Can you help us, Sarah, understand?
Yeah, because I think that's a, goodness gracious, I work at a tech company. That joke never gets old. Yeah, because I think that's what, like, the interesting question, right, is not relitigating this settlement, getting forward, like, what is the real impact in terms of both Google and YouTube as a platform for the creators, but also everyone else that COPPA touches. And I think that there is a way to do that, and it's something that came up in the earlier panel. They didn't use the word because we're the wonkier panel and we use wonkier terms, but it's something called rebuttable presumption, and this was something that we put in our comments that we filed with the COPPA proceeding, because the FTC late last year asked a large number of questions about, okay, should we look at COPPA? What are some of the questions we have, especially in light of the settlement? And it's this idea about how you treat users who are watching made-for-kids content. So there is a declaration the YouTube creators say, yes, this is content directed for kids or not. YouTube is implementing a system using machine learning and AI that we can talk more about to basically check that, right, and making sure that there's not fraud or abuse in terms of those declarations. But we all know that AI is not perfect for that kind of system, so we don't want to over-rely on that. But essentially, if any content is made for kids, the assumption is that whoever is watching that is a child. And there's a question about whether or not there should be an ability to rebut that presumption. So you could say, me as a avid Harry Potter fan or avid Lego fan, I don't want to call people out, but I know someone in this audience is an avid Lego fan who's very much an adult, or SpongeBob SquarePants, or any of these examples that we used before, right? We could all go down and list our guilty pleasures. The question is, like, should you be able to, if a platform goes through reasonable procedures to verify that viewer is in fact an adult, then be treated as an adult and have the comments features turned on, be able to have the playlist features, the notifications, and all these other things that really distinguish YouTube as a platform from traditional broadcast or other platforms. And that's something I think some others in the industry have called for, is like, that basically avoids this idea that you have to be treated as a child no matter if you are or not, simply because of the content you watch. And so we think that's a really important thing that the FTC can look at going forward, that can kind of help strike this balance and really get to like what the heart of COPPA is supposed to be, which is the protection of kids, very much the protection of their personal information. And nobody argues that we shouldn't do that, and do that job very, very well. But then you also want to make sure that that law is clear and it's easy to follow. So people who want to do the right thing, like the creators that just spoke, have like a really good, like, clear rules of the road about how to do the right thing, and that there's strong enforcement when that's not the case. But that comes with the clarity. And so we're thinking with things like that, with a lot more clarity about what is supposed to be made for kids, what is not considered made for kids content, because that can be unclear. It can also be ephemeral. And so audience is something I think that a lot of people have talked about, but I think that what's lost in all of that conversation is the context and how important that is. And so I think, like with something like crafting, the context of that is even more important than perhaps some others. And so I think that kind of clarity and that balance in terms of those things can all help us navigate this post-settlement, post-2023 2013 world of COPPA.
So the challenge with any COPPA discussion is you always have to spend at least the first half just setting the table for everyone. So
Yeah.
I think we have it now. And procedurally, there are two things going on here. There's the settlement that the FTC reached with YouTube last year, and then there's the request for comments that the FTC made to update the rule, which they do every 5 years or so. So right now, the FTC has taken comments, and the window's just closed, and the FTC is going to be working on this over the next few months. And the issue, the fundamental issue that I want our panel to talk about is this question of, are we in a position now of treating adults as if they were children? Because that to me is the fundamental balance that Congress was trying to strike back in 1998. On the one hand, yes, protect children. On the other hand, to the greatest extent possible, avoid that presumption that adults might be children. And the critical question there is, what counts as directed to children? You heard the last panel talk about this. You heard some of our creators explain that may be applied in particularly arbitrary ways, particularly unfair ways, that content that's created by and for women or younger women might be even more likely to be labeled as directed to children. So what can the FTC do right now to make that more clear in the absence of, as Angela noted, any litigation and just having these guidance documents out there that say things like, well, if you have cartoons or dolls or things like that, or toys, you might be considered directed to children. What can the FTC do right now? And I'm going to do this in a kind of lightning round, so please throw out your quick thoughts as we move forward.
Well, I kind of disagree with the question because I think that when you say treat an adult like a child, what it really means for COPPA purposes is that their privacy is now protected in a way it wasn't protected before. And all these other things about not being able to comment and so forth are not requirements of the COPPA law. So if everybody had privacy protections, we would be in a different position. So I don't think it's actually an insult to treat, to give people privacy protections.
Okay, so we didn't really clarify this before. So what does it mean when COPPA is triggered? What is the legal burden, and why is this a problem? Why does it interfere with the connection between the content creator and the user? Someone? Phyllis? Amelia?
So it seems very technical, and I think it can be viewed as very technical, especially if you are an operator who is kind of coming to this without the context, right? So you've been operating in an environment where these particular requirements weren't implemented, and now they are being implemented. Theoretically, you could view COPPA as a speed bump. That there aren't, within reason, there aren't particular prohibited practices, but you have to insert a parent or someone putatively, as an adult, into the decision making before particular collections and disclosures and engagement. You mean what
is it that COPPA requires?
So there's an opt-in kind of hand raise, and it's more than just a checkbox. In particular, in situations, for example, in a situation where comments are permitted and you can have user engagement, you would want to put in place a system where someone has indicated, I'm an adult, and I then consent to what will go on in this environment. It is complicated when you're talking about the operation by individuals on a larger platform, and that's somewhat different in terms of what we're looking at now, although, as Baron, as you pointed out, in 2013, the FTC did talk about YouTube. And so the question is, and what I heard on the prior panel from operators is that there's very little control of the platform in which the operators are engaging, and maybe there isn't a uniform way for an operator to seek that parental consent on a platform in order to continue with some of the features like comments or behaviorally targeted advertising. But there is this kind of stop, pause, don't engage with kids in whatever way the law defines it before you get that express verifiable consent and then continue. If you don't get it, then you're supposed to stop.
So Jim, we hear this all the time. So people say, well, COPPA, all it requires is parental consent, and then you're good to go. Is it really so simple?
It's not, and that's probably the biggest failing of COPPA. I think when Congress enacted COPPA, it assumed that there would become sort of automated mechanisms in which people could get that parental consent, and no good mechanisms have actually evolved. The only thing that's out there is hand me your credit card, I'll charge you 5 cents and then give you a 5-cent refund, and then that way I know that's an adult, because presumably only adults have credit cards. So that part of COPPA has always been this big gaping hole that Congress thought was going to be sort of the safety net for COPPA. But the other thing I want to talk about is, I want to go back, just take a step back and talk about procedure, especially for some staffers we may have in the audience here. Think about where we are and where we just came from. Again, you heard there are no cases. Well, the FTC generally doesn't bring cases. Well, they do bring cases, but then they all settle out. And it's between the FTC and whoever the defendant was to sort of define what the terms of that settlement is. Unfortunately, as we're seeing with the YouTube settlement, that now has secondary, tertiary, all the way down 7, 8 levels of impact, and those people were not invited to that party to have that settlement. And they did that at the exact same time there was already a proceeding open. So we're now filing comments on a proceeding which has essentially been superseded by a settlement that nobody got to play in. And it's even worse because of the way that the FTC brought this particular action, was there was no ability for anybody to even comment on the settlement. It really was a totally smoke-filled room, and frankly, probably people on both sides would have liked to have a say in what happened with that settlement.
Because normally settlements get submitted to a court and you can file comments.
Right, and you can file comments.
At least that's one of the options the FTC has.
Right, and it wasn't taken in this road, so nobody got to sort of engage in this discussion. And so now we're trying to play this sort of catch-up game of filing comments in a proceeding about a settlement we don't have any right to file comments on, but which really is going to have probably more impact on what happens with COPPA than anything the FTC can do going forward. I mean, we've already charted this new course because of YouTube, and I understand that YouTube is sort of one player in this ecosystem, but it's really a large player in this ecosystem, and nobody is going to do anything that doesn't sort of follow what YouTube is doing here for risk of $42,500 a pop, in potential liability.
So I just want to make one thing clear. So Phyllis talked about operators. So COPPA is not new. The FTC's brought plenty of enforcement actions against operators in the past, but they've been websites who are doing their own business, creating their own content. This is the first time that COPPA is being applied to a platform where there are a long tail of content creators, such as the people we had in our last panel, who are now themselves being subject to COPPA. That's the fundamental change here. Those people don't have legal departments. They're, usually single operators. Sometimes it's a small team. They're now having to figure out how COPPA applies to them, and they're now struggling with that directed to standard, given the lack of clarity from the FTC in a way that's much more difficult than when bigger media companies had to do that in the past.
I just want to kind of pause for a second, though, because we're talking a lot about the settlement, as we should, right? That was big news. But also, since the 2013 rule, there's been a lot of change in terms of technology, in terms of content, how people consume it, the audiences. So it's not just that there are new questions as a result of the settlement. The settlement does bring new questions, but it's also, there are a lot of questions that have been opened since 2013. And so I didn't want to kind of lose that it's only the case that we're asking these hard questions about COPPA. It's also nice to kind of pressure test rules and laws after they've been written. But there has been this change, I think. There's more research that's been done about the content that's created and how it's consumed, and that's really, really important to bring into this, and not just just the settlement.
We have about less than 15 minutes. So what can the FTC do to provide greater clarity on what counts as directed to children, really quickly?
They could certainly open the rule. Short of the rule, they have a lot of tools in their toolbox. I think Commissioner Phillips could speak to that and what all is available. It could just be guidance, enforcement policy statements. Phyllis probably knows more about that than anybody. But there is that question about whether or not they should open up and consider a full.
But I'm asking something more like, how do you go from a list of words like, cereal and toys and cartoons to something that's more helpful to people like these folks?
I mean, I will say, in the FTC's defense, I guess I'll put myself in that position. When you have this list of factors, in a way it can be viewed as a gift, and I think that's the way the FTC would have viewed it, that it's better for operators to kind of match themselves up against a broader array of factors, some of which are very concrete. Some are, I saw this in one of the comments, context and, that may have been Google's comment, context and something else. But, what's the look and the feel and the taste and then there's the who am I intending to get to and who is actually there. But, you could put it all of these ingredients in a soup and cook it and you're supposed to come out for the most part with an answer. I do understand that there are the margins, and I'm looking directly at you, but I'm not sure that the margins are as wide quite as you said. We're directed to a 4-year-old or we're directed to a 60-year-old. And the FTC, now Angela, I think you would dispute how active the FTC has been, but the FTC hasn't taken the hard cases. They've left that to some discretion. And the cases primarily, you understand whether a property is directed to kids or not. And so if I were to put on my hat, I think crafting would fall within the not directed to kids bucket because of a very broad, it's got a much broader appeal. Directed to families is another, but that's a tricky one, right? Directed to families. And that's where I think there could be quite a bit of additional guidance that comes out because there is some confusion. Your general audience, and you might have some kids there, is one thing. You're directed to kids, and that is your sweet spot, is another thing. We're going to do co-viewing of kids and families. That falls within this middle bucket, and where does that get you, and what does your implementation look like? The FTC did kind of throw all of this wide open and maybe scare some people in the questionnaire that they issued, where they are asking what to do about properties that are not intended to be directed to kids, weren't designed for kids, but that have a large number of children participating. And you can see people getting very nervous about that potentially broadening beyond the 10 factors and having the law reach a whole other category that it might not have been intended to reach. But I would say, wearing my best advocate hat for operators, that having those 10 factors can be a gift because you can make your best argument that you are not directed to kids, where there aren't bright lines.
Right. But we have had a real shift here because we're not talking about companies with legal departments and limited liability in corporate form. We're now talking about a university professor and a young person who's created a YouTube channel and a person whose family is now creating content, right? We're talking about small entrepreneurs who have to make a decision about can they risk this enormous legal liability?
Well, I'll ask Sarah a question. What would you do in the case of somebody who believes they've been misidentified?
That's a great question. I think that there are processes in place to kind of consult with that appeal. I think we've laid this out in a blog post, I think last week, and there'll be more information, I think, about that. But there is a chance to kind of consult with YouTube and say, we didn't think this designation was right. And then again, there's the stopgap measure of the AI system. But I think we're a month in? And so I think it's going to take a while.
But there's two different risks here. There's the risk that YouTube makes a mistake and takes them down and essentially maybe puts them out of business or forces them to change the nature of their content. That's bad. That may actually put someone out of business. But it's not as bad as the FTC coming after somebody and then slapping them with a penalty. And you might say the FTC may not do that, but Angela, if I'm not mistaken in reading your comments, it sounds like some watchdogs out there intend to be on the watch, and understandably so, to look to see if there are content creators that you think are covered by the rule that are putting their content out there, and they have to think about that risk. And everybody may mean well, but if you're doing this as a passion project, you may just decide it's not worth it, or you may decide to really, as some of our creators were noting, you may start putting more adult content into your videos in order to make them less obviously directed towards children. And that in turn, this is one of the things that the petition talked about, that in turn is going to change the nature of content out there for kids and make it ironically more adult. It might mean more vulgarities. It might mean a change in content overall. I mean, these are the second order consequences we're dealing with. So how do we think about that balance?
Well, I don't think, from speaking for my groups, that we would be coming after, like, say, the crafters, because we want to protect kids, and we want so all creators are not the same. Nickelodeon is a creator, but they do have legal counsel. They do have, they have the ability to, and so, so what drives me crazy more is when you have like Disney saying, well, none of our shows none of our websites except for, the Penguins one are actually child directed. Huh? I think the problem is that, there is a big middle area, but there's also a lot of things where it's very clear they are child directed, but a lot of companies will then say, oh no, we're not child directed. And we see this especially with apps. And so those are the people that we're going to go after, people that are either they're big and they're still doing something wrong, like YouTube, or there's something where they're really, really, truly misrepresenting. We're not going to go after the borderline cases, just like the FTC is not likely to go after borderline cases. It's just not worth the effort.
Okay, our content creators don't look terribly
I know, I
reassured.
understand. I wouldn't feel reassured either. But it is a problem that is the way the FTC has chosen to define that you can't know whether something is child-directed in their view until there's been a case brought. And there's so few cases, there's no really, explanation of what that means. And, I've thought about like whether people could just say, we are child-directed, we're not child-directed, because I think a lot of parents think things are child-directed and they think their kids are protected when they don't actually.
So what about co-viewing? What about the, Harry, he creates content, Mother Goose Club, that's really, it's for parents to watch with their very, very young children, preschoolers.
But the parents don't have the choice to say, we don't want behavioral targeting unless COPPA applies. So even the fact that the parent might be watching with the kid, that doesn't change the fact that children could be manipulated through behavioral advertising. So I don't see how having a parent in the room, they haven't given actual consent in terms of COPPA, and the child isn't protected.
Yeah, I mean, the question is, aren't they essentially giving consent? They've logged into their YouTube account, and they're allowing their children to watch to watch these videos. Aren't they giving consent to that? Why not?
Because they haven't consented to the behavioral advertising. Their choice is you can watch it and let your kid be targeted advertised to, or you can't watch it at all. That's not really a choice.
Okay. Yes, it is. I mean, it really is. And the problem is if we just say, you can't have targeted advertising, we know the impact, the revenue impact of that. What is that going to do for the future of new creation?
Well, we don't know the revenue impact of that.
Well, it's difficult to know. We have some reports.
And there's plenty of people making a lot of money with contextual advertising.
Well, so here's the thing about contextual advertising. Some people can make a lot of money if the context in which they're advertising is very valuable, right? If you're advertising, let's say it's product openings, unwrappings, you might make a lot of money because the unwrappings are for a toy, and you can target ads to that. That's a very valuable form of contextual advertising. But if you're just, creating general purpose content, contextual advertising isn't worth very much. Those are the people who need to have, advertising that is targeted. We say behavioral. What we really mean is it's targeted to something other than the immediate context you're seeing. But we only have a few minutes, so and Sarah noted there are a bunch of other issues here we want to talk about. So I just want to go down the line here. If you could just, each of you tell the audience, what are the other critical issues that you think they need to be aware of in this context? Amelia?
So to some extent, I think it's out of the FTC's hands at this point. We saw from their previous rulemaking, it took 3 years. Even if we sped it up, that's probably at least another year. And we've seen 2 major COPPA proposals at the federal level. We have the California Consumer Protection Act, which has protections up to age 16. We have over in Europe with companies like Google who operate all over the world have to deal with a regime that has differing protections for kids under 16. To some extent, I think the key here is to provide as much insight about what laws creators in particular have to follow, but what that law should be and whether we should be more flexible. I feel like that battle at this point is almost lost, and we should be talking about how to make it more practical for the people who have to actually implement these new provisions.
And one of that sets of people is schools and educators. You work a lot on the intersection between COPPA and education policy. What's the very short version of that?
That it is impossible. Many state laws have found and rolled back having an opt-in regime, saying that parents have to proactively consent to each and everything, because unfortunately, you don't always have engaged parents. And you had in Louisiana, for example, parents going to, or teachers going to parents' homes and others, and you had kids that missed out on being added to the state scholarship fund because they couldn't get parental sign-off. They couldn't get the signature. And so it's really important to remember that there are unintended consequences here, and I think, as I said, where we're going with all of this and what we've seen with the student privacy protections is an underlying framework of privacy protections that apply across the board, not protections parents have to consent to. And so exactly what the boundaries of that are going to be yet to be seen.
Okay. We're in lightning round here because we need to leave some time for our chat with Commissioner Phillips. Phyllis.
You opened up so many ideas. Okay, so one thing that we haven't spoken about that I do think is kind of fascinating about the rule is that it governs the entire life cycle of personal information that is collected from an individual. And I found kind of fascinating, Angela, in your organization's comments, the idea of kind of the orphaned parts of the rule, that the data minimization requirements and the security and confidentiality requirements, while they are a key part of the rule, those parts haven't been fleshed out as much as perhaps they could be to give additional guidance on the back end. This isn't even on the front end when you're talking about information collection, but what happens when you have that information and how you protect the user's information when you have it. So that's a part that I think is interesting, and I know there's been a lot of concern about how well notice and consent really works. And we've had a long time to grapple with this rule. I mean, it's so interesting to me that it's been around for X number of years, and people still at every conference we talk to are like, well, the FTC should educate us more about it. I mean, you know, I'm not sure that there are other laws that really have this kind of sense that people just, if they only knew more about it, they'd comply a little better, and why isn't there better education?
And do you think that's because of the inherent ambiguity of COPPA's central definitions, or what?
I don't know what it's due to. I really don't, because well, maybe because it's complicated, but also because the ecosystem in which it applies is constantly evolving.
Okay, last words. We have to wrap up here. So quickly down the line.
There's like a million issues with it, right? Which is why the FTC asked a number of questions, and probably the average number of pages of comments are about 15 to 20 for everyone that filed comments, if not longer. I think I was reading yours, Angela, it was about 70. So I think there's an extraordinary number of issues, but I think to pull up a little bit, the big question is, it's a notice and consent framework, right? So how do we achieve that without creating notice fatigue, right? So that we're really focusing people on that. How do we balance these like really good protections with ensuring that there is this nice diversity and democracy of content coming on? And how do we get people who are complying in this post-2013, post-settlement world information so that they can do the right thing? And those are my 3 really high-level points. I think the biggest ones for us would be the rebuttable presumption issue and clarity on what is general audience and what isn't. But it's these questions of when there are tensions of data minimization and notice and consent, and there's a lot there, and I think we'll have many panels in the future to come.
Yep. Jim.
So I'll dive down into the weeds. One particular issue that I think the FTC has to grapple with is the question of voice recognition, speech recognition. The fact of the matter is the way we interact with computers, human-computer interfaces are changing very, very rapidly. And what the FTC said in 2017, I think it was that voice collection was essentially a violation of COPPA, but they would not enforce it so long as soon as a voice pattern was collected, it was immediately, the function for which it was requested would be done, and then it would all be completely destroyed. That's fine. The problem is that companies need a way of being able to fine-tune their AI so that they can actually understand child speech, which is very different than adult speech. And so essentially, we may be leaving our children behind, even though they're the generation that's probably going to want to use voice recognition and voice interaction with computers. And so I think we really need to take a hard look about ways in which we can allow companies to better their AI and better their ability to do speech recognitions without recognizing individual voices and collecting that data.
And more on that in the TechFreedom comments. Yeah. Final word?
I think the biggest problem is that the whole model of notice and consent doesn't work anymore. There's just, people don't read privacy policies. Even if they did, they're not going to understand them. And no one knows what's really going on behind the scenes and knowing how this information is being put together and used by all these different companies we've never even heard of. So I think we have to, and this will obviously take legislation, but move more to more data minimization. That is part of COPPA, but also just prohibiting certain uses of data. And I'll stop there.
Okay. Well, thank you very much to our panel. It's been a pleasure to have all of you. I'm going to have Commissioner Phillips come join me for a little fireside chat. And I just want to note, since we have an overwhelmingly female panel, that our Ashkan Kazarian on the Tech Policy Podcast does in her interviews an ongoing Women in Tech series. So if you haven't listened to those episodes, you might be interested in that, as well as the many wonderful interviews that Ashkan does. So thank you all for joining us. Commissioner Phillips is going to come up here and join me. So thank you. Commissioner Phillips is one of 5 commissioners on the Federal Trade Commission. He worked on the Hill before that, which is how I got to know him as one of the most thoughtful and humorous people in Washington. So, yeah, try not to set too high a bar for him today. And he's spoken several times about COPPA and how to interpret it. So, Commissioner Phillips, thank you for joining us today.
Thanks for having me.
Well, I just want to ask any initial reactions to either of the panels you heard today, and I just also want to note you are limited in what you can say. You can't comment on pending proceedings, which includes the rule update and enforcement actions. So I won't put you on the spot about those.
The other really important caveat is that everything I say is just what I'm saying, not necessarily the views of my colleagues in the commission as a whole.
Right.
You know, there was a lot that's been said over the course of the 2 panels. I think was really interesting. I think there are 2 big meta takeaways that I take from it. The first is that these are complex issues. And there is a tendency, I think, unfortunately, in the context of the privacy debate, to simply say, privacy, that's a word, it's good, I want more of it. But it's rather like freedom, right? I want more freedom too, but when you're talking in specifics and you're thinking about what the application of the principle is, your view of whether a particular law or enforcement mechanism or rule may depend a lot on what the specifics are. So that's sort of the first takeaway that I have. And the second takeaway is this. The initial or intuitive or first time you hear an appeal of a given policy position may not adequately take into account all of the follow-on effects. And the really interesting part of this debate to me, we have been talking a terrific amount about privacy nationally, in particular in the last few years. I think it's bubbling up as an issue in a way I don't believe that we've seen in my lifetime, certainly not outside the context of, let's say, national security, right? Fourth Amendment, people are thinking about privacy a lot. Those issues tend to pop up more. But commercial data privacy, in my lifetime, I don't know that we've talked about these issues so much. But oftentimes, like if you read the Privacy Project of the New York Times, it's a very one-sided conversation. This is an instance where we're seeing in life and in effect in people's careers and their jobs, some of the costs of privacy. We're seeing a bit of balance in the way that we're having the conversation here about COPPA, and I just think that's really interesting.
Well, I think in a way, you're falling into your own trap there, because even saying costs of privacy violates your first rule. Your first rule is let's try to break down privacy more concretely into its component parts and then analyze those. So how should we think about privacy here when in the COPPA context? What are the subcomponents that we should be looking at and trying to talk about more clearly?
Well, in the context of COPPA, I think we've got a law, right? And we talked a little bit about what animated the law. In particular, and I'll sort of pick on one of the earlier panels, we spent a lot of time talking today about behavioral advertising and the persistent identifiers that enable it, right, that make it possible. We also spent a lot of time talking about things like comments, right? From the perspective of COPPA, the law, and sort of the animating principles, those could be two very different things, right? The ability of someone to reach out to you, right, is much closer to what I think everyone agrees we were talking about in the context of COPPA, whereas a persistent identifier, maybe you think the FTC got it right in 2013, maybe you think they didn't, but it's something different.
Okay, so your agency is reconsidering some of these fundamental questions. Is that potentially in scope to rethink the 2013 amendments? So do you think there might be ways to do a better job of what the FTC did in 2013?
I mean, you sort of said at the beginning, we're in the midst of a proceeding, and we have taken in a great deal of input, and I don't want to prejudge that.
You're hearing people talk about these questions.
Certainly that's something about which people are talking. I think what you can see right now is that the changes that can be made through rulemaking can have a tremendously large impact, and that's really important to remember.
Well, Jim talked about this. The YouTube settlement has had a tremendously large impact, but that wasn't done through rulemaking, and there wasn't an opportunity for people to comment. Just as a procedural matter, how do you think the FTC should solicit public comment from affected parties before making changes like that? Would you want those things to go through rulemaking, understanding that you do have to bring enforcement actions? How do you decide when something requires public comment?
Well, to some extent, it's statutorily defined, right? So in YouTube, you're talking about a civil penalty enforcement action, so it's in federal court. A lot of what we do is administrative, and then you have that notice and comment capability. Fundamentally, a rule change requires under the law, depending on the context in which you're talking, but in this context, under the APA, it requires that sort of public input.
The Administrative Procedure Act.
Sorry. Let me just add something. What's interesting about a case like the YouTube case, or a case like the Facebook case, and that was a pre-existing order with the FTC, is when you do enforcement with platforms, things are almost by definition at scale, which means they're going to have a broad impact. If you're targeting a smaller entity, right? I'm trying to think of a good example in the context of COPPA. The two we've done this year are TikTok and YouTube, neither of which are small entities. But we do all sorts of consumer protection cases. Many of them are against smaller companies. The ramifications of what you're doing aren't necessarily as large. When you do anything with YouTube, much broader ramifications.
Well, and in particular, as to whether this was a rule change, I read earlier from that footnote from the 2013 FTC order that specifically cited Facebook and YouTube as examples of general audience sites and said that COPPA wasn't going to apply unless there was actual knowledge. And yet here we are without a rule change because of an enforcement action. That has been changed. The FTC has now come out and said, no, this is not just one general audience site. This is a site that has subcomponents, some of which could be directed to children. And that subcomponent idea is in COPPA, it's in the statute, but it had never been applied before to channels on a website like that. So that's a pretty big change. And that's why we're here. That's why people are raising these concerns about a law that's now changed in its application without public comment, and that started January 1st, I believe. So they're dealing with that even as this rulemaking update is underway.
So I'd argue there are a number of different reasons we're here. So one is a statute. One is a rulemaking conducted under the statute. Another is a settlement reached in a case. And you heard this on that last panel. Another is the implementation of that settlement, right? In essence, the settlement at core says, follow COPPA. And then there's this question, what does that mean? Right? So there's both the settlement and its implementation. There's a consideration of another rule change. And I think I heard a reference earlier, there's also some talk in Congress about expanding COPPA. So there are a lot of different phenomena.
Two bills out there. Yeah. Okay, so I want to move on to the big picture, but do you have anything else to say to content creators out there about how, not specifics, but in general, in what way their input may be incorporated?
So I think the first thing is to say thanks. Like, it's very, when you're doing public policy and you're thinking about policies that impact a wide variety of people, it's really important to hear from the people who are impacted. And so I had the opportunity to meet two of the folks here not so long ago. Jeremy came to our COPPA workshop that we held in terms of the rulemaking. But Forrest, he just made a video online where he kind of called us out. And I think that kind of citizen engagement is really, really important.
So you've got almost 875,000, I think, signatures on that petition. That's parents, that's content creators, that's people whose content might be affected by the settlement. And then there were another 175,000 comments filed in the docket. There might actually be more, we don't know, because there were so many comments filed that the regulations.gov website can't keep up, so we're not even sure how many there are. But as far as I know, that's the most public attention that has been paid to an FTC proceeding, maybe ever, but maybe since the late 1970s when the FTC tried to regulate the advertising of cereal to children. That prompted a big backlash. The Washington Post called the agency the national nanny, and that prompted a furious response from Congress, a Democratic Congress, which really clipped the agency's wings, removed some of its rulemaking powers, and actually briefly closed the agency. Does that historical parallel inform your thinking today?
The short answer is yes. I think that the nature of the agency, let's step back from COPPA actually for just a moment. The nature of the agency is that our core jurisdiction is defined more or less by the word unfair, and to some extent also by the word deceptive. Deceptive has a more understandable meaning, but the word unfair is a very big word, right? It can capture a lot of things, and most importantly, it can capture one thing for you and a different thing for me. Where you have capacious legal authority, the instinct and under certain historical circumstances, the tendency even to say, that's bad and I want to stop it, and that's bad and I want to stop it, and the other thing is bad and I want to stop it, can be very strong. Letters come in a lot, in particular from some of the bosses of some of the people in this room from Congress being like, I don't like this, you should stop it. I don't like that, you should stop it. And it's almost always earnest. People are often genuinely concerned, but there is also a concern in running around without thinking very carefully, doing effectively what is legislation. And so our wings were sort of clipped for that. And as I sit here now and I look out at the world, there's a big debate going on in Congress right now about what kind of rulemaking authority we should have.
In privacy legislation.
In privacy. That debate is about applying the sort of easier APA, that's Administrative Procedures Act, rulemaking authority mechanism to privacy. That's what we have in COPPA. So in 2013, whether you like it or not, putting persistent identifiers under the category of information that brings you subject to the requirements of COPPA, including verified parental consent. That was a big change in the policy. When you give rulemaking authority and you don't cabin that rulemaking authority, there is a lot of room for agencies themselves to understand the policy. We get a lot of input from the public. That's really important, but that's a great deal of power.
And when you say when Congress didn't cabin that authority, I said this earlier, in 1998, COPPA listed a bunch of things that were personal information like name and address and so on. And then it said, and any other unique identifier that the commission determines allows the contacting of a unique individual. And that has been interpreted then to mean any cookie, and therefore has brought behavioral advertising into the scope of COPPA when that was a great surprise to many people.
Yes.
So that's the kind of discretion we're talking about. You worked on the Hill. You actually helped to write laws. What advice would you give to Congress about how to think about how much of those decisions to keep to Congress and how much to give to the FTC?
So I'm an Article 1 guy, meaning I believe that fundamentally the best place where policy is made is Congress, and that's because they have a mandate to do it that's different from the kind of mandate that an agency has, that any agency.
Are you running for re-election this year? No. Yeah.
It's always hard to figure out how to answer that question, but the best answer is that there's this thing called the Hatch Act, and I don't get near the word election. I'm not running for anything, and never will. But when you think as Congress about what kind of policy we ought to have, there are going to be terrific moments of tension. And maybe you're in a place where you just want to get a bill done. It's going to be really important to your boss. It's going to be really important to the American public, which is, what you're there to serve, or your more specific constituency than that. But be wary of just delegating that authority to unelected bureaucrats, right? There is a cost that comes to that. And when people say, well, we want to provide flexibility, and flexibility is good, right? Everybody likes flexibility. It's like privacy. But it also means that at the end of the day, many of the bigger decisions can be made by the agency. And it's up to Congress to determine how that rulemaking ought to get made. Congress can put guiding rails, right? Guardrails on how rulemaking goes on.
So years ago, we called the FTC the Federal Technology Commission, because for better or worse, it is the default regulator of technology in America. Whether you like a particular decision it makes or not, you're going to get stuck with it, either because unfairness is broad and open-ended and allows you to regulate, or because a specific statute like COPPA just ends up getting triggered by technological change, or because Congress comes along later and tasks you with dealing with privacy or whatever new technological issue is out there. What have you learned from, besides this issue we just discussed, what have you learned from the experience of COPPA in how to think about the FTC's role in regulating technology and trying to stay ahead of the curve?
So I think presuming that we as government can stay ahead of the curve is quite a presumption. I think fundamentally, the important lesson for me on COPPA is that, number one, it's Congress that sets the policy. And number two, that as our economy digitizes, right, and as the use of data becomes endemic, and it's everywhere in the economy, the ramifications of these policy decisions are broader than you might realize than you might have realized they were ex ante. There is a tendency in the privacy debate to talk about the economy as if it's like 4 different firms, right? It's Google, it's Apple, it's Facebook, whatever. That's not true. We're talking about tens of thousands, if not more, of firms all across the economy doing a wide variety of things. In terms of content creators, I'm getting to it. I don't know, what's the number? It's more than tens of thousands. Huge numbers of people are affected. And that's just really important to take into account.
But what do you do with that? I mean, when you know that it's not just 4 firms or even 40 firms, but it's that long tail of hundreds of thousands of people who are creating content who have to worry about legal liability, what does that mean for a regulator and an agency that takes enforcement actions? How do you provide them enough assurance that they can, decide, they can assure their spouse that they're not going to lose their home if the FTC comes after them and imposes some huge penalty on them for example?
I mean, look, I think we have to engage in the kind of conversation that everyone is having now. I think that's important. I think it's incumbent upon us to explain through guidance, what we are doing. I think it is incumbent upon the bar and others to watch what we're doing. I will say this. It isn't as if there's a record of enforcement action against content creators. I do want to add one note, actually. And just something for people to think about. There was a lot of discussion that the guidance that's been put out on what is directed to children, whether that's the right guidance. To the extent you have a statute that looks at that issue, that's actually a really hard thing to define, right? We've talked also today about the problematics of setting a particular age, right? And that's the only arbitrary bright line I can think of when it comes to kids. Beyond that, a multi-factor test that involves a lot of the things we've been talking about, however open it is to judgment, and judgment is something that we as law enforcers have to exercise, may be the right way to go about that. But that said, I do think listening, providing information to the public, I think that's really important.
Just to close, you talked about the need for humility, and that's very admirable. Of course, many people in the Congress just figure that they can just delegate these hard questions to you at the Federal Trade Commission, and you'll figure them out. So they may be actually eager to write open-ended language that just kicks the can over to you. That's a hard habit to break Congress of. Is there anything that you can say to them besides just don't do that, don't trust us to make these decisions? How would you stiffen their spine and get them to take more of those policy-making decisions for themselves?
I mean, I think I would let's take today, right? Again, people have differing views on the rulemaking that we did in 2013, but it's a big decision, right? Congress is good at making big decisions. It's designed to make big decisions. It's hard to legislate. But the fact that it's hard to legislate shouldn't in any way say to someone, and so you shouldn't do it, right? The scheme of our Constitution is one that makes making big decisions for the whole of society that affect a wide variety of people difficult. What it requires, basically, is broad consensus. But that's okay, because you're making law, and law comes with teeth. So there's a democratic reason why Congress ought to keep the power that it has. But there's another reason, too. And it has to do with the ability of firms in the economy to operate and people to plan their businesses going forward. There are things that agencies do that are sometimes not done with that level of broad consensus. Take, not to pick on our sister agency, but take net neutrality. And what you can see over time, depending on the context, is switches in policy. You want to adjust policy for the development of the economy, for the development of technology. What you don't want is rules that change back and forth depending on when people are elected. That's a level of uncertainty that makes business planning really hard. Avoiding the delegation problem, not allowing rulemaking, but making sure that it's the details that are left to the agencies, but the policy decisions are made by Congress, limits the degree to which the rules can change over time. And that allows for a certain stasis. And I want to come back to the content creators and also all of the people who participate online. The more constant the rule is, the easier it is to understand, both for the people who want to make money and whose careers are at issue, and the parents making decisions about their children, and the people just going online trying to figure out what to do. One of the most important themes we have in the privacy discussion more broadly is that people don't know what's going on. I can't count the number of times I have heard from legislators to citizens, friends, whatever. We have no idea what's happening. The more complex the rule, the more the rule changes, the less you get that effect. Like consistency, uniformity, allow for greater clarity, and that's very important. So when you hear someone say, I think we need 50 different, I'm gonna go off a sort of little tangent here, 50 different state laws on this issue. Think about the consumer. if you're thinking about the consumer's ability to understand what's in, what's out, what do I have to raise my hand for? What are they going to ask me if you're talking about opt-out versus opt-in? The more things you have to take into account, the harder it is, the longer those privacy policies are going to be. Very important to have consistency, very important to have uniformity.
So we're at time, so, no, this is great. I've been at this for 11 years now. We're gonna do many more events on COPPA. And suppose that in 4 or 5 years, we're doing another COPPA event and we're gonna play a video clip of you just making some prediction, just something that you want to communicate to that panel. If you had to pick one short thing to say to them, what would you say?
I think I'm not supposed to make those predictions.
No, you are. It's just, what, if you wanted to have a, kind of like, see, I told you so, here's how you should have thought about this, here's the thing that I really tried to emphasize back in 2020, what would that one thing be?
I think the thing I'd say is we're not going to answer all the questions, right? There's no application of the COPPA rule, there's no structure of COPPA, there's no federal privacy law that will give everyone the sense that they understand everything that is going on in the economy as a whole. And there's no application of any of these things that won't have an effect. So I'm not sure that's a prediction, but I'm not really good at predicting, so I try to avoid it.
Like the Star Wars franchise, COPPA will never end. It'll just keep going. It'll have ups and downs. We'll be here. We'll hope that you come back for all these future events. Thank you, Commissioner Philips, for coming today. Thank you to our content creators, to all of our experts who came today, and stay tuned because eventually we're going to get an update from the FTC. I imagine second quarter. I don't know. I'm not putting you on the spot. But
not even predicting that.
I'm not going to predict anything, but something's going to happen, and when it does, we'll have another discussion about this, what it means for content creators. Thank you all for coming, and all of us will stay around here and engage with you if you have any questions. Thank you to our live audience. You can find our past discussions about COPPA, which C-SPAN also covered, also online. We'll put those up on our YouTube so you can watch the whole series from start to finish and figure out how the characters relate to each other and the long arcs of revenge in the Star Wars of privacy. Thank you.
Thanks for having me.